I'm Lance Fryrear, Defender of Justice, and you may want to know what's going to happen for your first offense DUI in Washington State. In this video, I'm going to cover 3 things about your first offense DUI in Washington State. 1, when is my court date going to be? 2, what's likely to happen to me in court? And 3, what steps can you take today to improve your chances for your court date? So if you're watching this video, you or someone you know may have been pulled over for a DUI. You probably didn't plan on getting a DUI. You've never been in trouble before. A police officer may have given you a breath test, may have taken a blood draw. They may have taken you to jail, or they may have just let you go home. So you may have a court date that's coming up, or you may wonder, why don't I have a court date? So for Washington State, there's basically 2 general situations for your first offense DUI. 1, you were pulled over by a state trooper or a sheriff. Or 2, you're pulled over by a city police officer. So there are some exceptions, but for the most part, if you're pulled over by a sheriff or a state patrol, you're not going to have a court date right away. And that's because the sheriff or the state patrol person is really only empowered to arrest for the DUI. Typically, they need to send in their DUI report to the prosecutor for them to make a decision what to file and when to file your DUI case into a court. So that means it could be a week, a month, or even 6 months before you have a court date. That doesn't mean you shouldn't do anything. You should probably do some stuff to help your case, but we'll talk about that in a second. In the second situation, you may have been pulled over by a city of Lynnwood police officer, or Seattle, or Edmonds, or Shoreline, or wherever. On a city case, usually the officer is empowered to write their own ticket into the court. In that case, if you were pulled over on a Saturday, you probably have court on Monday, and you better be ready to deal with it. So you may have a court date right away, you may not. What you do have to deal with right away is the Department of Licensing issue. Now, this video is being filmed in June of 2020. In June of 2020, if you had a breath test that was over the limit or you refused a breath test, you've got 7 days from the date of the incident to request a licensing hearing. So laws change, so I want you to check with an attorney. You can call our office if you want to see what the deadline is, but just don't rest on that issue. The officer is supposed to give you a form to request a hearing. They don't always do that. So again, if you did not get a form to request a licensing hearing to fight about a suspension of your license, again, check with an attorney right away. So for step 2 of what I want to teach you today is what you should expect when you do go to court. When you go to court, the first court date is called an arraignment. And at that arraignment date, the court is required to consider certain things about your record. Now, if you're watching this and this is your first offense DUI, there's no mandatory condition the court must follow. On a second DUI, the court has to order that you install an interlock device on your car where you have to blow to start your car, and that's sort of a real pain. So some courts, such as Seattle, will be more aggressive in their pretrial conditions of release when you show up at your arraignment. So you're going to show up at your arraignment date in a courthouse, hopefully with an attorney, and you're going to enter a plea of not guilty. At that time, there's going to be a prosecutor there usually. They're going to look at your police report. Hey, was the breath test real high? Did you blow a 0.20? You're really, really drunk? Or did you just blow like a 0.09? So depending on what the situation is in the report, an accident's worse than a non-accident, a high breath test is worse than a low breath test, the court's going to set conditions. Typical conditions would be don't drink, don't drive without a license and insurance, and come back for your court date. Sort of more difficult conditions they can set if you have a bad case would be put an interlock in your car where you have to blow to start your car. Or even worse, wear a scram bracelet on your ankle where you have to be monitored for alcohol 24/7. It's really annoying and you do not want to have to do that. So you'll enter a plea of not guilty, the conditions will be set, and then you'll get another court date. Between the arraignment and the next court date, get yourself an attorney. Either a private attorney, or if you can't afford a private attorney, apply for the public defender. Follow the court's instructions, because each court is unique. Finally, what I said I would talk about, number 3, is what you can do today to improve your chances in court. So whether you have a court date or not, talk to an attorney, and most of us attorneys, if you don't have a record, are going to tell you, hey, go get an alcohol and drug evaluation that is going to show you don't have a problem with alcohol. In this state, if you're charged with DUI, the court's going to require that anyway. So you might as well get it out of the way. Now, there are some exceptions, so you need to talk to an attorney and ask your attorney about what you should do for sure. But most of the time, you want to schedule that alcohol drug evaluation. What's an alcohol and drug evaluation? It's where you answer questions with a number 2 pencil. In the last year, I drank to excess 0 times, 1 time, or more than 1 time. Well, this time probably, right? And other questions like that. And then the evaluator will make a recommendation. If you sort of have a reasonable case, they're going to usually say you don't have a significant problem with alcohol and recommend you do 2 things. An alcohol and drug information school, which is an 8-hour class, and a 2-hour DUI victims panel. So usually on a first offense, it's a good idea to get those things done quickly so the prosecutor in court can be impressed with how proactive you are. Now, this video is not legal advice. You should speak to an attorney. Feel free to call our office. Again, we are the law offices of Lance Fryrear. Been around for 20 years in Lynnwood and represented over 5,000 clients. Many of those first-time offense DUIs. But check with an attorney. Just don't wait and do nothing, because this is valuable time where you can improve your case. So if you have your first offense DUI, don't panic. A first offense is usually inconvenient. It's not a life ruiner. A second offense can be. So take advantage of this time, get a hold of good counsel, and I hope that you find this video helpful. Again, Lance Fryrear, Defender of Justice. We're here for you if you need us. Thank you.